open that hearing. And as soon as Natalie figures out what it's about, she's going to tell us.
Thank you, Mr. Chairman. Senate Bill 243 creates requirements and procedures for settlement agreements that involve minors. Section 1 adds a new section of law. It provides that a person with legal custody of a minor may settle or compromise and enter into a settlement agreement with a person against whom the minor has a claim or from whom the minor is to receive proceeds from the sale of real estate for a settlement for any estate or from any other source under certain circumstances. First, the minor cannot have an appointed guardian or conservator. Second, the total amount of the settlement proceeds due to the minor after a reduction from the total settlement amount of all medical expenses, medical liens, all other liens, and reasonable attorney fees and cost has to be $25,000 or less. And then third, the monies payable under the settlement agreement have to be paid as provided in subsections C and D. The person entering into the settlement agreement on behalf of the minor has to complete an affidavit or verified statement that attests that the person, one, has made a reasonable inquiry, and that to the best of the person's knowledge, the minor will be fully compensated by the settlement. Two, they understand and acknowledge that that person is obligated by law to deposit the settlement directly into a restricted savings or other restricted investment account. Subsection C provides that monies paid under the settlement agreement have to be deposited into that restricted savings or other restricted investment account, and that only allows withdrawals from that account under the circumstances that are specified in subsection D, or it's used to purchase an annuity by direct payment to the issuer of the annuity with the minor designated as the sole beneficiary of that annuity. If the minor is under the care, custody, and control of the state, then the Secretary for Children and Families has to establish a restricted trust account or sub-account of a trust account that earns interest for the benefit of the minor for the purpose of receiving monies payable to the minor under that settlement agreement. Subsection D provides that the monies in the minor's restricted savings or other account cannot be withdrawn, removed, paid out, or transferred to any person, including the minor, except pursuant to a court order upon the minor attaining the age of majority or being otherwise emancipated or on the minor's death. The Senate committee did add an amendment here to provide that upon the minor's or account holder's death, the balance of that account shall be paid to the death payable on death beneficiary, or if there isn't a named payable on death beneficiary, then in accordance with the probate code. Subsection E provides that a signed settlement agreement entered into on behalf of the minor in compliance with subsection A is binding on the minor without the need for approval of the court. It also has the same force and effect as if the minor were a competent adult entering into a settlement agreement. It shall serve to fully release all claims of the minor encompassed by the settlement agreement, and it may be relied on by a financial institution or other entity when opening a restricted savings or other restricted investment account or purchasing that annuity on behalf of the minor child. Subsection F provides that any person or entity against whom a minor has a claim that settles the claim with the minor in good faith under this section shall not be liable to the minor for claims arising from that settlement. Further, the insurer who in good faith transfers funds into a restricted savings or other restricted investment account or purchases that annuity at the direction of the minor or the minor's representative shall not be liable to the minor or the minor's representative for any claims arising from the use of those funds after that transfer is complete. The Senate committee added an amendment here also to provide that a financial institution who in good faith opens that restricted savings account at the direction of a minor or the minor's representative shall not be liable to them for any claims arising from the use of those funds. Subsection G provides that nothing in this section shall prevent any person acting on behalf of the minor from filing for guardianship, limited guardianship, or conservatorship in district court, and then requesting the district court to approve the settlement on behalf of the minor and oversee those proceeds. The Senate committee added a new subsection here, subsection H, to provide that nothing in this section shall prevent the minor or a person acting on behalf of the minor from filing and asking for approval from the court for that settlement agreement, the affidavit or verified statement of the person entering into that settlement agreement, the terms and disposition of the settlement proceeds, or any other matter related to the agreement or arising from claims that are encompassed by that agreement. The court shall award docket fees required to file the action to the minor or the person acting on behalf of the minor. The Senate also added 3 amendatory sections to the bill. Section 2 amends KSA 38-1707, the Kansas Uniform Transfers to Minors Act statute that allows for fiduciaries to make transfers for the benefit of minors. Current law there authorizes a transfer over $10,000 to be made only if it's authorized by the court, and this amendment would require that court authorization only if it's a transfer over $25,000. Section 3 amends KSA 59-30-53, the Act for Obtaining a Guardian or Conservator statute, providing a natural guardian of a minor the right to control the minor child unless a guardian has been appointed. Current law there authorizes that natural guardian to hold and trust and manage the minor's estate when the total property does not exceed $10,000 in value, unless a guardian or conservator has been appointed. And this bill changes that amount to $25,000 in value. And then finally, Section 4 amends KSA 59-30-55. That's the Act for Obtaining a Guardian or a Conservator statute that authorizes a court having control over assets vested in a minor to do certain things with those assets. Current law there provides that a court with control of an amount not exceeding $10,000 can order payment of the money to the minor or any person to hold in trust and manage for the minor. This bill allows that payment to happen when the court has control over an amount not exceeding $25,000. And then further in that statute, the current law provides that when a guardian has been appointed, a court with control of an amount not exceeding $10,000 can authorize deposit of that money in a savings account payable to the guardian for the benefit of the minor. And this bill would allow that deposit when the court has control over an amount not exceeding $25,000. So the purpose of those amendatory sections is just to kind of bring those in line with the new section. And I can take any questions.
Any questions, committee? Representative Humphreys.
Thank you, Mr. Chair. So Natalie, besides these 3 sections that got amended, the other everything else is new. But what did we do before about all of these things? I mean, was it just? I guess my question is, what problem are we solving by adding the new section 1?
Mr. Chairman, I think that question might be better answered by the proponents since they kind of brought this legislation to you. So I'll let them kind of handle that.
Representative Carmichael.
Thank you, Ms. Scott. I believe this actually is not new law, is it? We've been going through settlement hearings for amounts in excess of $10,000 for as long as I've been a lawyer with substantially the same requirements.
So I think that there's no statute on the books that codifies those requirements right now. So outside the changes that we're making in these other acts where we're amending sections, and so the proponents would probably be better able to kind of explain the process that those settlement agreements go through currently.
I'll defer my question then to them because my recollection is $10,000 has been the statutory amount for these types of settlements for as long as I've practiced law. Thank you.
Not seeing any other questions. Thank you, Natalie. Committee, I show 3 proponents here in person. I did not ask the order you want to go. Craig, are you first? Yes, Larry Ann's first. Craig's first. Craig, come on up.
Thank you, Mr. Chairman. Representative Humphreys and Representative Carmichael, I'll try to answer your questions at the beginning of my testimony. My name is Craig Blumrick. I'm an attorney here in Topeka with the law firm of Larson and Blumrick. I don't want to tell you how many years I've been practicing, but a fair number here in Topeka. And I do a lot of personal injury work on the defense side, and that's why I've been asked to speak. My testimony is on behalf of the American Property Casualty Insurance Association, but I want to pique your interest just a little bit that this bill is actually the product of collaboration with the Kansas Trial Lawyers Association and the Kansas Bankers Association, who all we've met and the amendments that have been added are from those organizations. Their proponents will speak after me. Representative Carmichael, we've been practicing a long time. I can't remember how many times people have talked to me and said, I've got my minor child was involved in a car accident. There's an emergency room bill for $2,000. The insurance company will pay us something, maybe $1,000 for pain and suffering. Can we just sign something and get that done? Insurance companies have contacted me from outside the state of Kansas and said, well, how big does a settlement have to be before we have to get court approval? And I've looked that up many, many times in Kansas law, and the law is it's one size fits all. If it's a $50 settlement or a $5 million settlement, it is not binding under current Kansas law, under common law, until the court approves it. The purpose of this particular bill is to provide an alternative means using an affidavit, having the same sworn testimony from the person acting on behalf of the minor, the same, they promise to do the same things, but they do it in an affidavit so that you do not have to bear the expense of filing an action with the court and wait for the court to be able to schedule that in, we all know, very congested dockets right now, to approve a small settlement. So the purpose of this bill would be to allow any settlement with a net value to the minor of $25,000 or less. So let's say it's a $30,000 settlement, but there's an attorney fee and there are liens that get paid. As long as the minor isn't actually receiving a net of more than $25,000, this statutory affidavit could be used to allow the legal custodian to sign a release and take the money on behalf of the minor, just as if you were in front of a court. I'll give you a very short example of why this is necessary, in my opinion. Right now, I have a really sad case where a woman in Wyandotte County lost her husband in an automobile accident. It was his fault. It's not a liability issue, but the no-fault benefits under the insurance policy are $10,800 for the child, for his dependent. It's going to take us almost 6 months to get that money into her hands. No fault of anybody, it's just the system. Wyandotte County requires that you first file the action, get it assigned to a judge, then you have to have a hearing to have the parent appointed as next friend, and then we have to have a hearing to hear the evidence to approve a settlement, which is a no-brainer. It's $10,800 and it's all for the minor, and that's all you can get from the coverage. Now, that's an extreme example. I don't want to say that's always the example, but this affidavit approach would allow us to bypass that, not giving up anything. I think one very important part of this bill is that you're not forced to use the affidavit. Any legal custodian or really any person involved in the settlement process can go to court if they want to. So it's not that you would be prejudicing somebody who may be a parent who's very concerned if this is fair, and I don't know if I'm the one that's qualified to fill out the affidavit, you can go to court. Nothing changes that. Hopefully that answers, that's at least in my opinion, why we need it. And in my practice, I know there are many, many times that this would have been very useful to do. Now, Representative Carmichael, the changes that are made were if we would go to court in the old, or before this, then the judge did have the discretion to say, $10,000, I'm just going to give it to you, parent, and I trust you. On the honor system, you need to use it for the benefit of your child without conservatorship, guardianship, filing anything. And then between 10,000 and 100,000, the judge had discretion to use restricted access accounts, maybe guardianship or conservatorship. But what this is an attempt to do, and the Kansas Bankers Association came in and said, if we're doing this, maybe it's time to look at, instead of 10,000, maybe we should bump the judges up to 25,000 if we're able to do an affidavit settlement for 25,000. So not to belabor the point, I'm happy to answer questions, but I think this is a useful bill, and I think it's been vetted pretty carefully. We've had several meetings about it. We've made changes to make sure all sides are fairly taken care of. So I would ask that you give favorable consideration.
Committee, any questions? Representative Carmichael?
Mr. Bloomreich, you are correct. The $10,000 amount, as soon as I opened the bill and looked at it again, was the amount that the court could entrust to the parent or natural guardian without the use of a restricted account or without a conservatorship. It has been a while since your client paid me substantially more than that $10,000 amount.
Please.
But now as I look back up on it, the young lady has done very well in her life, and we appreciate the professional manner in which you handled that litigation. I don't think there's a whole lot I need to add here, except one thing, and that is, Mr. Chairman, I'm sure that no matter how carefully the Senate has vetted this, there are changes that ought to be made, and I'm sure we can find them. Thank you.
And I won't comment on that. Thank you.
Further questions? Representative Mon. One more for you, I think.
Thank you, Mr. Chair. Council, so I'm this is an area of law that I'm not particularly familiar with, but I'm going to ask you the quintessential law school question. What could go wrong here? What would the other side of this argument, the other side of this bill say to us?
Well, one thing that did come up in the Senate was a question regarding the bill says the legal custodian. What if you have parents disagree? What if you have a divorce and we have joint custody between two parents and they don't agree? The answer, that's certainly a law school problem, something that could happen, but that's why this doesn't replace the court proceeding. It's just a tool. You would only use it in cases, I'm sure the insurance company would balk if it looked like there was a disagreement of any sort with respect to the affidavit. They would pay, and that's what this bill says, they would pay for this to go to court. There's a provision in here that any person can go to court, even to review the affidavit. So I think we thought about those issues, but again, given the collaboration here, it seems, I'm sure we could come up with something that would be bad, but for the most part, this appears to be very useful and workable.
So basically, the reason for that question is my concern is, yes, this seems in the great scheme of insurance settlements to be a small amount, And we also like to believe that all parents are looking out for the best interests of their kids. It's not always the case, and $25,000 may be enough for some unscrupulous parents who think that maybe this is a payday for them to abuse the system, and that's my concern. I mean, and I know we're not going to fix that, right? But that's just where I was coming from with that question, is trying to figure out, is this ripe for abuse in some way?
It's an excellent question, and it is built into the bill that if you use the affidavit, the parents can't get any money. I mean, this has to be put in a restricted access account where the parents do not, in a court hearing, the judge has the ability or the discretion to give some money to the parents for bills. They don't have that discretion under the affidavit. So it's probably safer for the minor in terms of making sure the money doesn't get tampered with. But I share your concern in terms of, I mean, if parents, we trust certainly the financial institutions to hold the money, and they do. So,
Representative Smith.
I think mine was pretty similar to what Representative Mon had there, so I'll accept that. Thank you.
sure.
Representative Carmichael again.
As I was thinking about your testimony, another thought came to mind. You did mention the fact that under the present system, sometimes, not in all districts, but in some districts, it takes time to get one of these cases docketed, judges signed, etc. Another source of delay that I can recall seeing was oftentimes courts and or insurers would pay the money into court, and then the money would go to the registry of the court, and then the court was not anxious to let go of the money until the court had been assured that the check had cleared. And sometimes by court rule, they would hold it 30 days, 45 days, and nobody got paid, including the hospital, the injured person, or heaven forbid, their lawyer. But I think this makes specific provision in circumstances where a plaintiff or claimant is represented by counsel that the funds can be transferred directly into an attorney trust account and the distribution made from there, as opposed to having the funds tied up in the registry. Am I understanding that generally correctly?
That's spot on. That's exactly right.
How is it that you all did such a good job on this, and yet we're still going to have to make changes?
Any further questions, committee? Okay, thank you.
Thank you.
Next, I have Callie Denton.
Thank you, Mr. Chairman and members of the committee. My name is Callie Denton. I'm with the Kansas Trial Lawyers Association, and I'm very happy to be here for the first time this year. KTLA is a proponent of the provision that I think has already been discussed a little bit so far, and that's the provision that preserves the status quo, allowing people to go to court and seek approval of the settlement agreements. The reason why we proposed this amendment to the original bill touches on exactly the concerns that are being discussed. There are times when settlement agreements are maybe of disagreement among parties, or there's a need, an attorney is recommending that the parents and the child seek the approval of a court to make sure that the interests of both are protected. And when the bill was first presented, there was nothing in it that said that the status quo was going to be changed, but we wanted to make sure that it was clear. And so new section 1H is the language that KTLA proposed. And I'll just take a little detour here and say thank you very much to Larry Ann and the proponents and the other stakeholders. We got together way before the hearing and were able to come to consensus. And it's just a lot more fun when we're able to come to committees and bring a consensus bill. And I do think that the provision improves the bill. It offers a lot more direction to parties as to what's able to happen in a proceeding, and if there is a need to go and sort out disagreements about what should happen with a settlement. So KTLA as a whole on the bill is neutral. I think this is a policy decision if the legislature wants to go beyond the probate code, beyond the Uniform Transfers to Minors Act, which is what is in place right now. I think there's a lot of arguments about easing court load, caseload, and also making things easier for parties that would suggest that it's meriting consideration. But KTLA's position is that our amendment is really integral to the success of the bill, and I would ask that when you work it, that you include it as it is in the bill now. And I'm happy to answer any questions.
Any questions? Okay, thank you.
Thank you so much.
Next, Kelly Vanswall.
Thank you, Chairman Patton and members of the committee for the opportunity to testify today in support of Senate Bill 243. Like the other conferees have said, we really appreciate everyone's work on this bill and coming together to reach a consensus. And it's always nice when you can find that agreement. The revisor did a great job explaining our amendments, but I will just kind of touch on our thought process behind them. Our stake in the game here is that these accounts and this money is put into financial institutions and then often worked out with. Can they take the money out? When can they take the money out? And those kinds of questions. So our first amendment is on page 3, and it touches on section D. The bill, as introduced, said that the money could be withdrawn when the minor passed away. We added language clarifying that a payable on death beneficiary could be added to that account. This is something you can add to most personal accounts so that when the account owner passes away, the money can immediately go to that beneficiary instead of going through the probate or estate process. Payable on death beneficiaries is in the current Kansas statute as it's recognized in the statute for estate planning purposes. We just thought this language would give comfort and clarity to the financial institutions that should something happen, they know who they can pay out. Our second amendment was on page 3 in section F, and that was creating language stating that the financial institution who opens the account is not responsible for tracking the use of the funds. For the other accounts we're mentioning in this act, the court-ordered accounts or the Kansas Uniform Transfers to Minor Acts, we do not track the use of those funds either. And we just thought adding clarity there and giving us the same kind of protection or very similar protection that's afforded the insurers in section F2. Kind of made sense there. And then our final ask was to increase the thresholds in the other accounts mentioned, the court order accounts and the Kansas Uniform Transfers to Minor account. Our thoughts there was that if we're going to allow these affidavit settlement accounts to go up to $25,000, it would make more sense to have all of the accounts go up to that level. And those thresholds have not been adjusted for a while. So we thought it would just make more sense to have them all in the same playing field. And I'm happy to take questions at the appropriate time.
Any questions, committee? Okay, thanks, Kelly.
Thank you.
Committee, I have written proponent testimony from the Kansas Association of Property and Casualty Insurance Companies and the National Association of Mutual Insurance Companies. Any other proponents? Are there any neutral or opponents? Okay, I'm seeing any. I'll close the hearing on Senate Bill 243. Committee, that is it for today and it for this week. I know, oh darn. Next week, an agenda came out today. It will change, hopefully tomorrow afternoon. We've been waiting on one bill for quite some, it was a complicated bill. Well, it's complicated to draft. I don't think it'll be complicated for us, I'm hoping. But that's going to get introduced tomorrow, I think, and head our way. And then, so I'll update the agenda then. Next week, we are very likely to work the two bills we heard this week, which were Senate Bill 189 and Senate Bill 243. So be ready on those. If you don't like the effective date or something like that, we might need to change that up. That's it though. So we're adjourned. Have a great, sounds strange saying great weekend on a Wednesday, but have a great weekend. I'll see you next week.